Dolly friends, this is Kitty
And I'm Totty.
and welcome to Little Bottle Nursery. Our channel is dedicated to our love of dolls and creating fun and positivity in the doll hobby, so stick around and have some Dolly fun. Hi Dolly friends, it's Kitty. Welcome back to those who've already watched part 1 of this video series. If you haven't watched part 1 yet, I have included a link in the description box, and I do encourage you to watch it first so that you have some context for what this video is about, which is part 2. In this 3-part series, I'm addressing an interesting Dolly topic and sharing some really valuable information with you about manufacturing in China, specifically what intellectual property protections and contract agreements are essential to protect an individual's work when they engage with a Chinese factory to manufacture their products. I'm also addressing how manufacturers get away with copying someone else's idea or product and the preventable measures to reduce the risk. There are 3 separate videos covering this topic. This is video number 2 or part 2, and there's a link to part 1 and 3 in the description box below. I will place up on screen the discussion points covered in all 3 videos. Part 1 was essentially an introduction video where I raised certain issues in a broad context, and then in subsequent videos I drill down with a lot more specific information. So in this video there'll be a strong focus on intellectual property and what protections are required to globally protect an individual's work. And then in video 3, there'll be lots of information about what contract agreements are essential if engaging with a Chinese manufacturer. There are timestamps available in the description box below should you wish to go straight to any specific topic. And whilst I'm chatting, I'll do some quick outfit changes on some of the dollies in our nursery. For our new viewers here today, my daughter and I have an eclectic collection of dolls. We collect all sorts of different dolls. So during this video series, you might see some vintage dolls, factory dolls from companies like Ashton Drake Galleries or Paradise Galleries, reborn dolls, GOTS dolls, even Barbie dolls. Autumn has arrived in Australia, so it's time to change some of our dolly crew into some warmer clothes. So for any of our viewers who are diving straight into this part 2 video without seeing part 1, I will take a brief moment just to touch on some points. So in part 1, I discussed that I decided to create this series of videos after recently seeing some very alarming comments made online by a couple of sculpt artists who did not put any contract arrangements in place with their Chinese manufacturers when they had their sculpts manufactured into kits. There were also comments made about how many sculpt artists used the same factory and many had their kits copied at least once. So with my professional background, it was fairly obvious to me that it would be worthwhile sharing some useful information about intellectual property and manufacturing agreements to educate the community about the potential pitfalls of manufacturing in China, especially when individuals have not registered their intellectual property in China and do not have a manufacturing agreement in place with their factory. I have no doubt that certain individuals from the reborn community will find any excuse to take offence at this video series. The type of individuals who constantly attack and bully others online and are too stupid to realise when someone is trying to give them a hand up and help them. Honestly, it's ridiculous the nonsense I've had to put up with in the past from certain individuals making nasty assumptions that there is some kind of sinister hidden agenda behind why I share this type of information. Newsflash, there's no sinister agenda. My daughter and I, we own 9 genuine reborn dolls and have another 3 arriving later this year. I'm a 2nd generation doll collector and my daughter is a 3rd generation collector. We take our doll collecting hobby seriously and we hope that our substantial financial investment into reborn dolls will actually be worth something in the future. From what I've seen currently going on in that part of the doll industry, if a number of changes are not made in regards to how certain individuals conduct their business operations, the very likely result is that industry will implode on itself. I distinctly remember something similar happening back in the late 90s when Chinese manufacturers successfully dominated the porcelain doll industry. So if it means copping a bit of unwarranted hate because I choose to share useful information that can actually help others from having their work copied, then I'm totally okay with taking the heat for it. So I want to first start with a disclaimer that not all Chinese manufacturers are dishonest, and if there are any sculpt artists who have not signed contracts with their Chinese manufacturer and they have not had their work copied, then they should count themselves as the lucky ones. The culture of doing business in Asian countries, particularly China, is very different to many Western parts of the world. And the factual information that I provide in this video series about some of the pitfalls of manufacturing in China is well documented, especially online. And I encourage you to take a look in the description box below at some of the online links that I have provided, and I encourage you to do your own research. So before I dive into discussing all things intellectual property, I want to first briefly touch on the risks of making public statements online about illegal, stolen or counterfeit products. Our regular viewers already know, although we choose to collect authentic dolls, we never have and never will publicly make any statements online about dolls or kits being counterfeit, stolen or illegal. There is a very important reason why we don't, and I'm going to share it with you so that you can avoid being involved in any potential legal trouble like a lawsuit. There can be many reasons why it's not illegal for Chinese manufacturers to copy an individual's work. I broadly spoke on those reasons in the part 1 video, and I will discuss these reasons more later in this video as well as in the part 3 video. Doll collectors need to be extremely careful publicly stating online that certain dolls or doll kits are counterfeit, stolen or illegal. If you have no legal proof to support your statement, and these Chinese manufacturers do have the legal right to produce what was originally an individual's work, then these Chinese manufacturers may come after you for defamation. And it was only very recently that this actually happened to an individual in our community with a high-profile YouTube doll channel. They thought they were doing the right thing in support of sculpt artists by outing a certain manufacturer of a particular doll that they thought was a counterfeit or stolen or illegal or a knockoff, and it backfired in a big way. And it's not the first time someone in our community has been threatened with legal action from these Chinese companies, so please be careful. The next time you consider publicly branding a doll or a kit as counterfeit, stolen or illegal or a knockoff, or outing a manufacturing company, you need to ask yourself the following. Can you prove with documented evidence that the manufacturer has stolen the sculpt artist's manufacturing molds or their intellectual property? Can you prove that certain manufacturers do not have the legal right to be reproducing a certain kit or doll? Because if you can't prove any of this, and the manufacturer you're taking a dig at can prove otherwise, you are going to find yourself in a lot of legal trouble. From the sculpt artist's perspective, I can understand and appreciate how they feel ripped off. However, it's the courts that have the power to carefully consider these types of issues based on intellectual property evidence. And if certain sculpt artists cannot prove in court that they own the intellectual property of the final product in full that's been manufactured, then the courts may not consider their product counterfeit, stolen or illegal. This may seem unfair, but this is the reality of business and law. What people also need to understand is that the way that these Chinese manufacturers generally operate their business, the reason why they believe they're not doing anything wrong or illegal is because they are often working within the legal parameters of their country, which I've already explained in the part 1 video. This is why Chinese manufacturing companies may take offence at individuals in the doll community making claims that what they are doing is illegal. Individuals who engage foreign manufacturers, like in China, need to respect the laws of the country that they are doing business in and need to comply with the laws that are in place in regards to manufacturing. Protecting one's work with intellectual property registered in China and implementing contracts with their Chinese manufacturer will achieve the best outcome for the individual. So just because you think in your own mind that a doll or a kit is counterfeit or stolen or illegal, it may not be in the eyes of the law. It's the courts who have the power to make those decisions, and they base their decisions on intellectual property merits. This is why it's so important for individuals to register their intellectual property not just in their own country, but in the country where they plan to manufacture and sell their products, and to have a manufacturing contract to protect their intellectual property during the manufacturing process so that their manufacturer cannot claim either part or full ownership of their final product because they have contributed technology and production costs. Educating collectors about the hobby is important, and I'm not disputing that. By all means, educate collectors on how and where to buy genuine doll kits. Teach collectors how to identify genuine products. Promote reborn dolls and kits as a special form of art, and show collectors the many benefits of purchasing from an artist. Promote the fact that genuine products, long term, they have far more value. I know for me, as a long-time doll collector, my preference is to purchase genuine dolls because I understand that they are worth much, much more decades later. But in regards to stating whether a product is counterfeit, stolen or illegal, given the courts have both the power and appropriate legal experience to make those decisions, those matters are best dealt with between the sculpt artist, the manufacturer in question and the courts. So before talking about intellectual property, I also want to just briefly touch on 3 to 4 main issues that are current in China, which reinforces why it's so important for individuals engaging with their Chinese manufacturers to have the correct IP protections and contract agreements in place. I briefly touched on this in video 1. In recent years, there's been a huge increase with certain Chinese manufacturers setting really low prices to attract new customers. Their intention is to get their hands on their client's product so that they can start manufacturing and selling the product as their own. If the manufacturing price is too good to be true, individuals can potentially be dealing with a manufacturer that just wants to take their product. Intellectual property theft is rife in China, particularly with trademarks. Although the Chinese government enacted law making it illegal for manufacturers to take brand names from its own customers, Chinese manufacturers have found loopholes to get around this law. Bad faith registrations occur when a manufacturer asks a relative or a subcontractor in another Chinese district to register their client's intellectual property, including their brand name, product name or logo as its own trademark. This practice makes it nearly impossible for individuals or business entities to invalidate the intellectual property. China works on a first-to-file system in their country, which means they will not recognise intellectual property used in other foreign countries first. Once a manufacturer registers their client's trademark in China as their own, they have the power to stop their client's goods from leaving China, because they legally own the client's trademark or other intellectual property rights. This is why it is so important for individuals to register their trademarks and other intellectual property rights well before approaching any Chinese manufacturers. Some manufacturers may wait years before asserting their rights on what was once their client's product. This generally happens when a client changes factories or if there is a sudden re-interest in a product. An example that comes to my mind is the Daddy's Little Girl doll by Ashton Drake Galleries. They wrapped up production on this doll some years ago, and then in recent years, this doll became hugely popular amongst Ashton Drake Gallery doll collectors. The collectors were quite desperate to get their hands on one of these dolls, and they were searching all over the internet and getting onto groups discussing where can I find this particular doll. And as I discussed in part 1, companies who copy products, they scan the internet for ideas on what to manufacture, and they will often lurk very quietly on Facebook group collector pages, and they will scan comments on other social media platforms like Instagram and YouTube to see what consumer interests are. Sure enough, a knockoff of this doll was made and sold on Amazon. To everyone's surprise, the doll was so accurate to the original, it even had the Ashton Drake Gallery stamp on the back of the neck. It was almost impossible to tell the difference between the two, and it certainly looked to me like the copy version had been manufactured from using the original moulds. I will now go on to discuss intellectual property in China. For our Aussie viewers, IP Australia, Austrade and the Arts Law Centre of Australia have published an enormous amount of useful advice to assist Aussie individuals and businesses with navigating the complexities of intellectual property, including manufacturing in China. So I have included some useful links in the description box below. So let's start with, what is IP? Intellectual property is a field of law that protects inventors, creators and entrepreneurs. In basic terms, it's the law of who owns the right to an idea. Intellectual property is crucial in protecting an individual's work. Copyright is a form of intellectual property and is an essential part of an individual's global intellectual property plan and can be used to protect artistic works. In Australia, copyright is automatic, so individuals do not need to formally register their copyright, although they do need to keep appropriate documentation as evidence. Under Australian law, artistic works are no longer covered by copyright once an individual manufactures 50 or more articles in Australia. Individuals who manufacture their artistic works will instead need to take out a design right to protect their work, which will only protect their work for a maximum of 10 years. Under the Berne Convention, artistic works are also covered under copyright law, which allows creators whose countries are signed up to this agreement to control how their work is used in other countries who are also signed up under this agreement. However, although countries around the world sign up to these various treaties and conventions like the Berne Convention, countries can still operate under their own set of laws, which foreign individuals and business entities need to comply with. I will now go on to discuss what the copyright requirements are when manufacturing in China. Individuals who manufacture in China often fail to take one important step: registering their copyright in China. This will present as a huge problem to individuals wanting to act upon copyright infringements, because there is a big difference between a valid copyright under the Berne Convention and an enforceable copyright in China. So if individuals want their copyright recognised in China, they will need to register it with the Copyright Centre of China. Unlike Australia, China has different copyright laws. Copyright continues to apply to mass-produced artistic works in China as long as it meets the standard copyright requirement of originality. China operates under an optional or voluntary copyright system. One of the biggest misconceptions is because copyright registration is optional in China, that individuals who are manufacturing in China do not have to register anything to have a valid copyright in China. Incorrect. The Chinese courts require proof of ownership, and an official Chinese copyright registration counts as evidence. With an official Chinese copyright registration, the Chinese courts and law enforcement can act swiftly in removing images and products from Chinese e-commerce platforms. There are many benefits of registering a copyright in China. It provides a proof of ownership and facilitates administrative and litigation enforcement much more swiftly in China. Basically, it reduces a lot of red tape and time. Chinese documentation, such as a copyright registration certificate, it carries far more weight as evidence in the Chinese courts than witness evidence. And things like personal declarations of copyright ownership by the creator, that won't be accepted as evidence in Chinese courts. Chinese registration for intellectual property carries far more weight than foreign registrations. Copyright registered overseas, for example, in the individual's home country, that'll need to be notarised by a public notary in their own country and legalised by the Chinese consulate in their own country as well before it can be submitted as evidence in the Chinese courts. The notarisation and legalisation process also needs to include translations into Chinese. Now, this process is very timely. It's very costly, it's wasting lots of valuable time, which is basically giving the infringing company more time to sell their copy products online. Many Chinese-based e-commerce platforms have a notice and takedown program. These programs require proof of IP rights in order to remove the infringing images, products and offers off their platform. Having a Chinese copyright registration facilitates this task much easier for both the Chinese e-commerce platform and the copyright owner. A Chinese copyright registration can also be more effective in supporting an individual's claim in a cease and desist letter. If an individual is facing issues with securing other forms of intellectual property in China, such as a trademark for their logo or a design registration for their product, Chinese copyright registrations can serve as a really good fallback. The optional Chinese copyright registration, it's inexpensive. It's around US dollars, $15 to $300, depending on what type of work that needs to be registered. The process on average takes about 6 months, which includes obtaining the copyright record certificate and then the stamped sample. And if you pay an extra small amount, it will actually reduce the wait time to about 3 months. Also worth noting that although a Chinese copyright can help individuals enforce their rights in China with copyright infringements, IP Australia actually encourages Australians who are going to manufacture their products in China to also register a design patent in China, as it will provide additional protection to their product. With the exception of copyright protection for artistic works, which has limited protections under the Berne Convention in China, all other intellectual property laws are not universal and do not cross country borders. This means intellectual property laws can be different from one country to another. So it is important that individuals or business entities check what the requirements are. They will need to work closely with a competent legal counsel to devise an effective global intellectual property strategy to ensure all their relevant rights are in place. Individuals and business entities should register their intellectual property in the country where they live, in the countries where they plan to manufacture, and in the countries where they plan to sell their products. Doing this will reduce the likelihood of their products being copied either by their manufacturer or from outside the supply chain. Also worth mentioning is that far too often the importance of registering a trademark is ignored. A trademark represents the commercial identity of an individual and is the most valuable business asset an individual can have. It can be sold, so there's a value associated with it. It can also be licensed, which means individuals can permit others to use it, subject to certain monetary terms and conditions. For individuals and smaller business entities who cannot afford legal contracts, the best thing that they can do to protect their business is protecting their name brand first and trademark it. This will set the business entity apart from the copycat companies, making it easier for the public to recognise them. A trademark gives individuals the exclusive rights to use their trademark for their product and can stop others in the marketplace from using an identical or similar product. It provides a strong basis for legal action and allows a much more rapid response to infringement. Generally speaking, it's much easier and cheaper to take action against someone who uses an individual's trademark without their permission. Having a trademark registration allows individuals to use the R symbol on their products, which lets the world know that their brand is protected. And although trademark registration can be expensive in some parts of the world, it provides the best protection. In China, registering a trademark is inexpensive. If individuals are going to manufacture their products in China, registering their trademark in China is absolutely essential to protect their work, even if they do not intend to sell their products in China. China operates under a first-to-file system for trademark registration. This means that China does not recognise unregistered trademarks. Individuals must register their trademark in China for any trademark protection. Without trademark protection, someone else can register an individual's trademark and prevent them from using it. This is even true if individuals are not conducting any sales in China and all they're doing is manufacturing a product in China. Someone else can, and probably will, register an individual's trademark and then stop them from exporting anything from China with that trademark unless the individual pays a licensing fee. This happens all the time in China and mostly happens to individuals and business entities from countries like Australia and the US, where they use common law first to use trademark registration system. It seems to happen much less to individuals and business entities from Europe because they usually know better because they employ the first to file system in their own countries. The first to file an application in China for a trademark gets priority to that trademark. It takes around 9 to 24 months for Chinese trademark approval, depending on the complexities. In the meantime, nobody can stop an individual from using the applied trademark. Individuals should obtain their trademark as soon as possible in order to avoid bad faith registrations and to protect themselves against counterfeiting. Individuals should trademark anything that can identify their business entity, their brand, products, services, logos, etc. Trademark registration should include Roman script, Chinese characters, the Mandarin word that sounds closest to the Chinese word, and the logo. Essentially, it is applying for the trademarks in both English and Chinese spellings. If individuals do not select a name in Chinese to register, a Chinese competitor will almost certainly select it for themselves. Individuals also need to carefully select what category their trademarks need to be categorised under, because not choosing all of the right categories can be as bad as not registering the trademarks at all. Registering trademarks in just one category leaves a massive opening for a competitor to register the individual's trademarks on the same product in a category that an individual did not select. If this happens, both the individual and the competitor can sell the product using the same trademarks. In China, manufacturers also have another way that they can assert they own their clients' intellectual property. If individuals do not have certain agreements in place with their Chinese manufacturer, clearly stating that their Chinese manufacturer does not own their intellectual property of their finished or final product, their Chinese manufacturer has the ability to assert that they own at least part or all of the intellectual property of the final product. The manufacturer can do this by demonstrating to the Chinese courts that they provided the technology, moulds, toolings, as well as production costs to create the final product. In the part 3 video, I'm actually going to cover this issue more extensively, as well as how to minimise those associated risks. So this concludes part 2 of this topic, intellectual property in China, in a nutshell. As you can see, it's not a straightforward process in China, so individuals would be wise to seek legal counsel to navigate all the complexities of doing business in China to prevent their work being taken from them. And now you can also see clearly why it is most unwise to be carelessly using the words counterfeit, stolen and illegal, because often it simply may not be the case. I have included a link in the description box for part 3 and look forward to you joining me, where I will discuss some of the different types of agreements individuals need to have in place with their Chinese manufacturer. If you enjoyed this video today, please give it a thumbs up because it really helps us out, and hit the subscribe button and the ring bell if you'd like to see more of our content. I will see you shortly for part 3, Dolly friends. Bye for now.